All right, so we are moving into Chapter 6 today, which deals with informed consent. And as always, there are particular articles for you to take a look at. Most notably, on page 175, you have the opinion in Canterbury versus Spence, which is quite honestly a rather stupid case, but one that leaves us with a very important piece of medical knowledge. There's a very quick article on page 180, informed but uneducated consent. And then the other two, which will be very interesting, the most interesting, page 189, cheaper than chimpanzees. And page 193, medical experimentation on prisoners. So those are the ones you want to focus on. So 175, 180, 189, and 193. Now, before we get into it, I wanted to talk about the concept of informed consent in general, because this is actually a very important concept, particularly within the field of medicine. You guys know, if you've ever been to the doctors, that anything that you do, you have to sign a consent. You have to give your consent to that doctor for your permission to do anything, to treat you in any way. They really can't do anything without your permission. And this is a concept called informed consent. And so I want to start off here with the basic definition for you, and this is something, of course, that you'll see on the exam, I'm sure. Informed consent is the knowledgeable and voluntary agreement by a patient to undergo intervention by a healthcare provider. Okay. The knowledgeable and voluntary agreement by a patient to undergo intervention by a healthcare provider. And there are three basic parts to informed consent. One is information. You must be given all of the relevant information. You have to know what the treatment is, what it entails, what the risks are, and so on. So you need to be given this basic information. Secondly, volition. You have to have the freedom to be able to make the decision for yourself as to what you want to have happen with regards to your own care. Volition would imply that you are of age to be able to make consent for yourself, that you are mentally stable enough to make consent for yourself, but primarily that you are uncoerced, that no one is forcing you or compelling you in some way. And that's why the third element, competence, kind of comes up as an alternative option or as an alternative concept, because we have the idea that we don't want people to be forced, but then we also have the concern over people who maybe are not in a mental state to be able to make the decision themselves, even if they did have a free choice. So that's why these are the three basic elements of informed consent: information, volition, and competence. Now, the concept of informed consent is one that is very, very important to us in the medical field today, but it's also a pretty new concept. If you go back through most of our history, we had a lot of those priestly model doctors who simply wanted to go in and do what they thought was in your best interest, regardless of what you believed. But in recent years, we have this idea of informed consent that prevents them from doing so. Well, that concept of informed consent is very recent, and in fact, it comes as the result of a very famous trial that takes place in Germany in the aftermath of World War II, called the Nuremberg trial. And from the Nuremberg trial, we get what now becomes known as the Nuremberg Code, that went into effect in 1947. Now, the Nuremberg Code is really the world's first attempt to give us a code of research ethics. And this comes about because I'm sure you guys are aware that during the Nazi period, there were a lot of very unethical experimentations that were conducted on concentration camp inmates. And so after the war, there were 20 Nazi doctors and 3 administrators who were put on trial for crimes against humanity, basically the unethical exploitation of these inmates. And so the end result of the Nuremberg trial, one of them was this code that laid down 10 basic points or 10 basic principles for research ethics. And I'm going to see if I can bring this up. You won't be able to see it because of the nature of where it is, but if I can do this, I can read off to you. There it is. The basic points. Now, there are 10 basic points. The whole thing fits onto a single piece of paper, but a third of that page is devoted to this topic of informed consent, and it's the very first of the 10 points. The first line says, "The voluntary consent of the human subject is absolutely essential." As you are, I'm sure, aware, those concentration camp inmates were not given any choice in the matter. They were forced into these experiments that were very painful, that were life-threatening, that in some cases brought us great knowledge, and in others served no purpose whatsoever. But they had no choice in the matter. But the Nuremberg Code established very specifically that the voluntary consent of the human subject is absolutely essential. And it goes on to explain that this means that the person involved should have legal capacity to give consent, should be so situated as to be able to exercise the free power of choice without intervention of any element of force, fraud, deceit, duress, overreaching, or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved to enable him to make an understanding and enlightened decision. So notice that what we're getting in this are basically the primary elements of what informed consent entails. All right, go through this slowly. This means that the person involved should have legal capacity to give consent. There's that idea of being of age, being someone who has the legal ability to make the decisions for themselves. Should be so situated as to be able to exercise free power of choice without intervention or any element of force, fraud, deceit, duress, overreaching, or other forms of coercion. So the choice has to be yours and yours alone. No one can force you or bribe you or coerce you in any way into doing it. And you must have sufficient knowledge to be able to make the decision. And so that's where the idea of information comes into it. And in fact, it goes on to state further that this latter element requires that before the acceptance of an affirmative decision by the experimental subject, there should be made known to him the nature, duration, and purpose of the experiment, the method and the means by which it's to be conducted, all inconveniences and hazards reasonably to be expected, and the side effects upon his health or person which may possibly come from his participation in the experiment. So it lays out that whole list there of things that the person needs to be informed of before you can get that signature of informed consent. And it says that it is the duty and the responsibility of the researcher, the doctor, to get this information from the patient before any type of treatment is given. I'm not going to go through the other 9 points of the Nuremberg Code. You're more than welcome to look that up yourself. Just type in Nuremberg Code into any search engine and you'll be able to find that. But in any event, that is what the Nuremberg Code entails, and it lays out those basic key points, those basic ideas for us. Now, the problem is that once this Nuremberg Code went into effect, of course, there was going to be a lot of doctors who embraced the idea, some, of course, who challenged it, and they tried to find exceptions to the rule. And specifically, they talked about what they wanted to call a therapeutic exception. And so we should probably draw a distinction between therapeutic and non-therapeutic. Okay. Therapeutic research is when something is being done specifically for the purpose of treating a sickness, an ailment. Maybe it's an experimental treatment. Maybe it's something that we haven't really firmed upon yet, but its intention is to try to help you, to try to make you better. Therefore, it's therapeutic. A non-therapeutic treatment is going to be one where the end result may or may not help you, but that's not really the point. The point is simply to gain knowledge, and that's what non-therapeutic research is supposed to do. So if I have one of those experiments where maybe I've got a group of people who are going to get a live drug, I've got another group of people who are going to get a placebo, and neither side knows which is which. What I'm doing may or may not help some people, but the point is that I'm gaining knowledge through that experiment of whether or not it is a psychological effect or whether or not the drug is actually a beneficial treatment for a particular condition. And so that's gaining me medical knowledge. That's non-therapeutic. It's not necessarily helping the patients that are involved. So with that being the case, we can see this distinction between the therapeutic and the non-therapeutic. Now, after Nuremberg, all doctors agreed that if we're dealing with a non-therapeutic form of research, then by all means, informed consent is 100% necessary. No one should have anything done to them against their will if it's going to not benefit them in any way. But many doctors argued for what they call a therapeutic exception. They wanted what we call a therapeutic exception. And that meant that they felt that while they should try to get the consent of the patient, if the doctor, in their professional belief, found that the treatment was necessary, that it was in the best interest of the patient, that they should have the right to override the patient and force them against their will. Again, think of a doctor like Dr. House, who is going to, force their will upon the patient because, in their belief, the patient's a complete moron. Why are they a moron? Because they don't agree with the doctor. So the doctor is the one who is supposed to get the information, to give the information, but the patient has the right to say yes or no. But many doctors felt that they know better than the patient does what's in the patient's best interest. And as a result of that, they wanted this therapeutic exception to be put in place so that they could do what they felt was in the best interest of the patient. And for quite a few years, this issue went back and forth and back and forth. And finally, the World Medical Association decided to make a ruling on this, as well as several other issues in the Nuremberg Code that were somewhat left open to debate. Like I said, the Nuremberg Code was only 1 page long. Many of the 10 points were only 1 sentence in length, and so they left a lot of room for interpretation. And so what the World Medical Association is going to do is they're going to meet in Helsinki, Finland in 1964, and they will draft what now becomes known as the Declaration of Helsinki. Okay. So the Declaration of Helsinki went into play in 1964. And what the Declaration of Helsinki does is it gives us a much longer, much more detailed code of ethics in the medical field. One that closes up a lot of the gaps and fills in some of the questionable elements from the Nuremberg Code. And it is this Declaration of Helsinki that we are using to this day. Now, in the Declaration of Helsinki, it said, yes, there is a therapeutic exception. However, that therapeutic exception is very, very limited. It only applies in the situation where you have a patient in a life or death situation. Something has to be done or that patient is in severe danger. And that patient is unconscious or insensible. So therefore, they can't give consent themselves. And so what emerges out of this therapeutic, what's left of this very limited therapeutic exception that the Declaration of Helsinki gives us, is what is now referred to as presumed consent. And we can define presumed consent as inferences about likely wishes for intervention by a healthcare professional when consent cannot be practically obtained without endangering the patient's life or limb. So, the only time that a doctor is going to be allowed to operate without the consent of a patient is if that patient is in a life or death situation. Something has got to be done right now, but this patient is not able to give consent. Maybe they are someone who is a perfectly rational individual most of the time who could make their consent, but because of whatever happened, they've been knocked insensible. You cannot, wake them up to ask them for consent without putting them in greater danger. And so under those circumstances, the doctor has the right to operate on that patient in order to pull them out of immediate danger. But that's as far as the rule of presumed consent is going to let us go. It can pull the doctor can use it to pull that patient out of immediate danger. But once that patient is out of immediate danger, then presumed consent is revoked and informed consent is back in place. The patient's family, somebody has to give consent on behalf of that person before the doctor can do anything other than pull them out of immediate danger. And the same thing applies if you have someone who is mentally incompetent in a life or death situation. Now, normally somebody who's mentally incompetent would have a power of attorney, a family member or someone who has the ability to make these decisions for them. But again, if it's a life or death situation and that power of attorney cannot be found in time, the doctor again can work under presumed consent in order to get the patient pulled out of immediate danger. But that's as far as presumed consent goes. Once the patient is out of immediate danger, that is all that the doctor is able to do. They cannot go any further without consent. So after the Declaration of Helsinki, to this day, this is where we stand with regards to this issue. Informed consent is an absolutely necessary thing before any patient can take a treatment, can be operated upon, can participate in an experiment or anything else. That informed consent becomes absolutely and totally necessary. So this is the background information basically with regards to this before we even get into the cases. But if we take a look at this first one I asked you to look at, which was on page 175, I believe it is. Yeah, 175. This is the opinion in the court case of Canterbury versus Spence. Now, this was heard by the U.S. Court of Appeals in 1972. What this is going to do is to establish exactly, at least for this country, what information has to be given by the doctor to the patient before they can even ask for a signature of informed consent. Now, the case itself is relatively stupid, so I'm not going to go into any real detail with regards to it, but let's instead just focus upon the issue of what comes out of it, and that is what's known now as the Disclosure Doctrine. Basically, the case involves a man who has a surgery on his back. And the surgery, everything goes fine. He had signed a signature of informed consent. Everything went well. But afterwards, he, instead of calling for a nurse for assistance, he decides he's going to get up out of bed after the surgery and go to the restroom and relieve himself. Well, he gets out of bed, he falls, and ends up paralyzing himself because of it. He claims that no one told him specifically that if he were to get out of bed and fall, that he would end up being paralyzed after the surgery. Therefore, his signature of informed consent wasn't valid. Well, when you're giving this person all of these instructions, when you're telling them of all the possible side effects that might occur as a result of this, you're probably not going to think that, if you happen to be stupid enough to try to get out of bed yourself without asking for help and fall, you're going to end up paralyzed. This isn't probably the type of thing that most doctors are going to think to tell him. So I mean, it was kind of weird litigation. But anyway, what does come out of it, like I said, that is important is this disclosure doctrine, because it has established for us since 1972 onwards what specific information has to be given to the patient before the doctor can even ask for a signature of informed consent. And what is interesting here is essentially all of these were already mentioned in the Nuremberg Code, and they were reiterated in the Declaration of Helsinki. So the disclosure doctrine gives us three things that we have to be informed of. First, we must be informed of all potential risks, hazards, and side effects. Okay? So before that doctor can ask for a signature of informed consent, you have to be told about all the risks that this procedure has, any potential hazards that are there, any side effects that might occur. You need to be informed of all of the possibilities of what could happen as a result of this treatment or this surgery. Secondly, you must be informed of any alternatives to the treatment. Okay. Is this treatment that you're being offered the only option? Are there alternative possibilities out there for you? What are those possibilities? Now, obviously, if the doctor is promoting this one, they can explain to you, here's why I think this is your best option, this is the one I think you should take, but they are still required to give you, to let you know that there are other possibilities, there are other options out there. And thirdly, what are the results of non-treatment? Okay. So what happens if you decide not to take this treatment at all? Will it end up killing you? Will you end up paralyzed? Will it, will you get an ache every time it rains? What's going to be the results if you don't seek this treatment? And so this is what the disclosure doctrine through Canterbury versus Spence gives to us and to the medical community of the U.S. Before a signature of informed consent can even be asked for, we must be informed of all the risks, hazards, and side effects, any alternatives to the treatment, and what the results of non-treatment are. And once we've been given that information, then that signature of informed consent can come to us. The court also said that this information must be presented to the patient in such a way that a reasonable person can make a reasonable decision. Now, I understand that what the court was trying to do was to bring in a sort of judgment with regards to the Canterbury case. And so why is it, that this guy wasn't informed? Well, is this reasonable to suppose? There's so many variables that could happen, so many possibilities that could happen. Some of these a 1 in 100 billion chance of what could happen. Is it possible for the doctor to tell you every last possible detail of what could happen? Probably not. Is what happened to this man the type of thing that a doctor probably would have thought about? No, because the patient was probably told, as all patients are, that if you need something, ring for the nurse. And so it's probably not reasonable. But the problem is that while that's the intention, this terminology of reasonable is kind of questionable. What exactly do we mean by a reasonable person? Again, many doctors would think that anyone who disagreed with them was unreasonable. What do we mean by a reasonable decision? It's a very ambiguous term. But nonetheless, that's the phrasing that's left for us. A reasonable person, this information must be presented in such a way that a reasonable person could make a reasonable decision. And that's basically all we need to get from the Canterbury versus Spence. On page 180, there's the article from Franz Ingelfinger, the title of which really says everything: Informed but Uneducated Consent. The argument that he makes is that it's okay for us to go through and give all of this relevant information to the patient. The problem is that most of the time the patient doesn't understand the information that they're being given. If you go in for any type of treatment, what's going to happen? Well, you're going to be handed several sheets of paper, and on those sheets of paper is all of the relevant information that you have to be told. And the doctor is going to say, read through this. If you have any questions, let me know, but otherwise sign it and we'll get started. And so what happens? In the case of most people, they begin looking at that. They see a whole bunch of words they don't understand, a whole bunch of Latin phrases, and before long they're thinking, well, if I don't sign this, I don't get the treatment I need. Therefore, they skip to the bottom and they sign it. They've given their informed consent, so to speak, but the whole point of informed consent is that you're making an intelligent decision based upon the information that you're given. But if you haven't actually read and understood the information that you're given, how can it truly be a signature of informed consent? And so Engelfinger believes that what we really need is a greater sense of understanding in the medical world. We need people to have a greater degree of knowledge of medical procedures. And so maybe that would entail we need to start teaching medical issues and biological issues much earlier than we do. Maybe we need to put a greater emphasis upon them. I mean, not everybody's going to be able to be a doctor, but at the same time, these individuals could have a much greater knowledge and therefore be able to better understand what they're reading and being told than what they do now. If we're serious about informed consent, then he says it also has to be educated consent. And so that's basically the argument that he makes with regards to that. Now, these first two articles that we looked at are dealing primarily with the informational side of informed consent. What information needs to be given to the patient, and the fact that the patient really needs to understand the information for it to be real information, for that signature to really count. The latter two articles, which are the much more interesting ones, I think, deal with the volitional element of informed consent. Remember that to have informed consent, the patient must be able to have the freedom to make the choice, to make the decision for themselves. Well, in 1961, before the Declaration of Helsinki, but after the Nuremberg Code, the doctors all over the world had began arguing that if we are going to take the Nuremberg Code seriously, if we are going to accept the idea of informed consent, then that would imply that we should not use prisoners in medical experimentation, because prisoners are a confined group of people. And as a result of that confinement, they are not in a position to meet the volitional component of informed consent. And if their consent cannot be given truly, then we have no business using them. And so in 1961, the World Medical Association proposed that we needed to pass a ruling, to pass a law that says that no prisoners should be used in medical experimentation because they're unable to meet the volitional component of informed consent. All over the world, you had doctors that were agreeing with this, that were signing off with this, all except for the US. In the United States, the doctors said no. The prison population is far too valuable to us. We need the prison population if medical science is going to advance. Why would the American doctors oppose when all the rest of the world seems okay with it? Because American doctors have to contend with something that the rest of the world doesn't. The FDA. The Food and Drug Administration. You may be aware that in the United States, it can take as much as 15 years to go from the developmental stages to having a drug actually out there on the market being sold and being used. That same drug could be on the market within 6 months in Mexico. In the United States, there are very strict rules with regards to the experimentation process, the development process, and most importantly, the testing process. And so let's say that we have some drug that has been brought forward, and we've developed it, we've designed it, we've tested it in the laboratory, and it looks good. Well, now it's time to test it on people. And according to the FDA, there's going to be 3 different stages in which we do this. The first is going to be a small group of people, maybe 30 or so. And what we're going to do is we're going to test the safety of that drug. We know that it's safe in the laboratory, but is it safe for human consumption? And so we're going to get about 30 volunteers, usually paid volunteers, and they will allow themselves to be the guinea pigs upon which this is tested. And we're going to find out if this drug really is safe for human use. If it passes that test, then we move on to the second stage. We get a larger group of maybe 300 this time. Now we're going to test the maximum dosage. We know that it's safe for people to use. Now, how much can they use? And so we're going to try to find out what's the maximum dosage that people can safely take. Is there a difference in terms of male or female? Is there a difference in terms of age? Is there a difference in terms of weight? We want to know what's the maximum dosage for each individual. And after it's gone through that testing, we go on to the last stage, a much larger group of maybe 3,000 people. And now we want to actually test it as a remedy. Does it actually work? Does it actually do what it's supposed to do? And so now we've got a product that works in the laboratory. We know that it's safe for human consumption. We know how much a person can safely take. Now, does it really work? Does it actually serve its purpose and work as a cure for whatever this ailment happens to be? So these stages have to be gone through before we can move on to the final step of bringing this product to the public and making a claim that it is an effective drug. Now, the American doctors said that in all 3 of these stages, and especially in the first one, the prisoners are crucial to getting good testing results. Why would this be? Well, there are several reasons why the American doctors have said that prisoners make the ideal test subjects. Let's start with what I guess is the most noble reason, and that is that because the prisoners are confined and watched, we can better trust the results that we're getting. If you look at the outside world, you have 30 people in the outside world that say, yeah, we agree to take this drug over the prescribed period of time and report back the results. Well, suppose that this drug has to be taken at exactly the same time every day. You only have the patient's word that they're doing that. If maybe you're supposed to abstain from alcohol while taking this drug, you only have the patient's word that they're doing that. But inside the confines of the prison, the subjects are going to be watched. They're going to be regulated. And so you know that if this drug has to be taken at a certain time, that it's going to be. You know that if they have to abstain from alcohol or if they have to eat only a specific diet, that can be seen to by the prison officials. And so the results, they will argue, from a prison subject is actually more trustworthy than that of a free population. So I guess that's the noblest reason. Another reason they give is money. As I said, particularly in the early stages, people are going to want compensation for putting themselves at risk. And so you are going to be offering payment to these people. In the outside world, you may be offering several $100s to somebody who is willing to go through with this test. Because of the environment of prison, because of the poverty of prison life, you might offer a prisoner $20 or $30 to do this experiment. And so it's going to be incredibly cheaper to use prisoners than it is to use free world population. And then, of course, the least noble reason is that the first stage, of course, is dangerous. Things can go wrong. If something goes wrong in the outside world, the media is going to be all over it. But inside the confines of the prison environment, no cameras are allowed, no news media. And so it's going to be much easier to sweep it under the carpet and cover it up if anything does happen. And so because of those three reasons primarily, the American doctors refused to sign off on it, and they said no. The prison population is crucial. We need prisoners as test subjects, especially in the first, but really in all of these. Because again, the belief is that the results they get from the prisoners are going to be more accurate than those of free world populations. So because of this, the debate has continued within this country and a few others as to whether or not prisoners should be allowed to participate in medical experiments or not. And that's what the two articles here deal with. Jessica Mitford, Cheaper Than Chimpanzees, on page 189, she, of course, is going to argue that the prison population is, as she puts it, in an iron compression chamber. These are individuals who are controlled and regulated in every aspect of their life. So how could we possibly imagine that these individuals would be able to, in any way, give real consent? Aren't they coerced in every aspect of their life? The concept of freedom is an illusion that's beyond the scope of prison life. But on the other hand, Carl Cohen, on page 193, Medical Experimentation for Prisoners, is going to argue no, this is not the case. The prison population still are rational human beings who have the ability to weigh options and make choices. And it would be wrong to take away their right to say whether or not they wanted to participate in this experiment or not. The choice should be theirs. And as long as there is no specific coercion taking place, as long as no one is holding a gun to their head and saying, you will do this or else, then there's no reason why the prisoner should not be allowed to participate if they choose to. And in fact, Cohen says it could actually be beneficial to the rehabilitation process to give them that choice, to give them that ability. Now, regardless of which side you end up being on, I think that once you read these, you will agree that Cohen's article is much more coherent. It is much easier to understand. Jessica Mitford is what we might call a sensation monger. She is going to go back and find the worst case scenarios. You could find something that's happened a million times perfectly, but once it went wrong, well, she's the type that's only going to talk about that once that it went wrong, not any other of the positive benefits. So she's going to grab onto something and run with it in that respect. She has this tendency to kind of be a sensation monger. She also doesn't worry too much about the fact that times have changed. A lot of the cases that she talks about in this article are from very early on in history. And, of course, if you go back before Nuremberg, before the code went into effect, it becomes almost a moot point to talk about informed consent because it didn't exist then. If you look at the fact that, in the early days of the 20th century, that a prison warden had almost absolute control and power over the prisoner without much in the way of regulation over him, that it was a lot easier for corruption to take place inside the prison system. You look at the reforms that have been made within the last 30 some odd 40 years in this country, and you'll find that there is a lot more regulation inside the prison, and that these wardens have a lot less power than they used to, which means a lot of the stuff that's going on in these cases could not happen in the present day. And so Mitford, even though you may agree with her, and even though if we look at the heart of the argument, you may find value to it, the way she goes about doing it really isn't the right way to do it. To see how to do an argument really well, turn to Carl Cohen. Cohen uses what in logic and critical thinking we call the principle of charity. Okay. The principle of charity means that instead of weakening or trying to take advantage of the loopholes in your opponent's argument, you actually work to strengthen your opponent's argument. You present the best possible view of your opponent's argument, the strongest view, and then attack it. And that's smart. Because, I mean, it would have been very easy, because Mitford's original argument here is riddled with holes. There's all kinds of things that could have been attacked very easily. But Cohen doesn't do that. He actually, in the opening part of his article, is going to strengthen her argument. He is going to make it much more coherent and much stronger than what she had it. And then he attacks that strongest version of the argument, which is why, from the standpoint of logic, I would argue that he has won this debate, because he is able to counter the claims that she's making, even in its strongest case. And so as you guys go into various aspects of your life, that's something to keep in mind. Use the principle of charity. Don't take advantage of the loopholes that you're given, but find the strongest version of your opponent's argument. Essentially, what's going to happen is that there are 5 key points that are going to come up. Cohen is going to refer to these 5 things as factors in a prisoner's life. Mitford is going to call these things coercions. So for Mitford, these 5 things we're going to look at here in a moment, these are coercions. They are things that are forcing the prisoner into making a particular decision. And of course, as we've seen, for a signature of informed consent to be valid, it has to be freely given. There can't be any type of coercion. Cohen, on the other hand, is going to say that what Mitford is calling coercion really isn't. These are simply factors that a prisoner has to deal with in their life, just like people in the outside world have certain factors that they have to deal with, things that they're going to consider and weigh in making a decision. But that doesn't mean that they're forced into the decision. It just means that they have certain things they're going to think about, just like anyone in the outside world would, before making the decision. So what are these 5 points? Well, first, the body of the prisoner is not under their own control. Okay. So the body of the prisoner is not under their own control. According to Mitford, as soon as a person walks into that prison, they are no longer under their own control. They are the property of the state. The guards, the warden, are going to dictate every aspect of their life. They're going to be told when to get up, when to go to bed, when to go to work, when to have break, when to have meals. Every aspect of the life is going to be completely controlled and regulated. And Mitford's argument is that that is a coercion because the prisoner becomes so accustomed to being dictated to that they forget how to make free choices, and they feel perhaps that they are somehow compelled by their condition simply to do what they're being told. And if somebody says, "Do you want to participate in this experiment?" they might think that they are required to. And so the body of the prisoner, it's not under their own control. They are regulated, they are controlled by someone else. And so there is no room for making free choice within that type of life. Secondly, the security of the prisoner. Is the concern of the warden. Okay. So as a prisoner, you are not supposed to take the law into your own hands. You're not supposed to look out for your own well-being, but rather you're trusting that the guards around you, the warden, that they are looking out for your interests and protecting your person. And so if you are not supposed to trust yourself to make these types of decisions, then how can you make a decision with regards to your own body? Thirdly, there's the question of poverty. When a prisoner goes into prison, they are stripped of everything. They lose everything going in. And so they are all brought down to the point of having nothing. If they're going to get anything, then they're going to need a paying job while in prison. A paying job in prison might bring you $20, $30 a month. Or alternatively, family members are allowed to come in and they'll be able to spend a certain amount of money in the commissary for the prisoner, but that's limited as well to maybe $20 in most cases. So the prisoner has virtually nothing. Suppose that someone comes into the prison and says, "Hey, I'll pay you $30 to participate in this experiment." You've just doubled your monthly income. You're thinking about how much you could do with that money and what you could buy in the commissary with that. And as a result, you may, in her opinion, be coerced or forced into participating out of the desire to have that extra income. And so that's coercion. Fourthly, boredom. Prison life is designed to be boring and monotonous. You see the same walls, the same hallways, the same people day in and day out. You do the same routine day in and day out. There's never any change, never any variation whatsoever. Now suppose that this experiment that you're involved in requires you to be transported to a hospital once a month. Doesn't sound like fun to most people, but to the prisoner, yeah, it's an ambulance ride. That's a chance to see new places, see different people. It breaks the monotony. It breaks up the boredom. Or even if it's within the confines of the prison, at least when you're going, to a different part of the prison, perhaps you're seeing perhaps different people who are coming in from the hospitals to conduct the experiment. So just simply the desire to eliminate that boredom is a coercive factor that's forcing them into it. And finally, 5 is the desire for freedom. The thing that the prisoner wants is to get out of prison. They want to be free. And so in the early days, deals were struck whereby they would say, "Hey, if you participate in this experiment, I'm going to knock 6 months off your sentence, or maybe a year off your sentence." And I would agree that that would be coercion, because that person is being offered something very, very tempting. And the desire to get out of prison and to get back to their life is so strong that perhaps they would be willing to risk all for that opportunity of getting out early. The problem is that now the warden no longer has that power to make that type of offer. That's something that has to come down through the courts. It's not something that the warden can unilaterally do like he did in the early part of the century. And so the best that we could take this for now would be that the prisoner might think, well, if I participate in this experiment, it might look like I'm trying to give something back to the community. And that might look really good to the parole board. So I am going to participate in this experiment in the hopes that the parole board will see me as doing something beneficial, and maybe that'll get me out of here quicker. There's no guarantee, like there was with the in the early days with the warden, but there's still that belief that maybe if I do this, I can get out of here. And so Mitford says that these 5 things are coercive elements that are forcing the prisoner to participate in experiments, sometimes experiments that are dangerous. Well, and she talks about, for example, a scurvy experiment. We've known for a long time what scurvy is and how to combat it. There was no need for this experiment to take place. The experiment actually had been refused in the outside world as unnecessary and dangerous. But this experimenter wanted to do it. So in the 1940s, he went into a prison, found a corrupted warden, and he essentially bribed him into letting him conduct this experiment. Well, of course, prisoners, for various reasons, participated in the experiment, and it did produce a lot of problems. I mean, scurvy is a very serious problem that could eventually lead to death, which in some cases it did. By picking out those worst case scenarios, she is showing us, how bad things can become. But there again, the problem is that experiment would not have been allowed to happen in the modern world. There's too much regulation inside the prison board. So many of the things that she believes or that she talks about that happened in the past could not happen in the present. But regardless, her argument is still that the prisoner is coerced by the condition of their imprisonment. And as a result of that, they are not able to give an adequate signature of informed consent. If a person cannot give a signature of informed consent, they cannot be used in the experiment. Therefore, we should, as the World Medical Association suggested, make it illegal to experiment on prisoners. Cohen says, now, this is the argument that Mitford has made, but essentially he says it's not a good enough argument. Because the things that she is referring to as coercions aren't really coercions at all. They are simply factors within the prisoner's life. And he gives a very nice we get a very nice example in which he talks about how what the difference is between coercion and a factor of life. And so I'll give you this now. Suppose that your boss, you're working for a company, and your boss comes up to you and says something like this. Every year, each one of our employees donates $50 to United Way. You're not going to let us down, are you? Now, the statement that's being made, the way it's being made, that implies a threat. If you don't donate this money to United Way, which makes our company look good, then you're probably not going to do so well around here. You're not going to get that promotion that you're looking for. Your new office you were hoping for, it's going to be a broom closet. All right, there's an implied threat in the way that this person said it. You will do this or else. That's coercion. That employee is being forced into donating this money to United Way, whether he wants to or not. That's coercion. On the other hand, suppose that one day you get a letter in the mail from United Way telling you about what it is that they do, their services, and they're asking you for a donation. You read that letter and decide to send them a check for $50. It's true that you wouldn't have sent them that money had you not received the letter in the mail. But there's no way that you could say that receiving that letter forced you into making the donation. You chose to read the letter. You could have thrown it away unopened like a lot of people do. but you chose to read it, and after reading it, you thought, hey, that sounds like a good program. I'm going to donate some money to that. So you made a choice based upon a factor that occurred in your life, but there was no coercion there. And likewise, if we look at the role of prisoners, he says if somebody went up to a prisoner and said, hey, you're going to participate in this experiment or you're going to spend the next 3 months in the hole, that is coercion. That's forcing the prisoner. But that's not what happens. Normally what happens is there's going to be a little notice that's posted up on the kiosk or the note board, wherever they place things in the particular prison, and it'll explain, here's this experiment that's being that we want to conduct here. We're looking for volunteers. Here's what it entails. Here's what you have to do. If you're interested, sign up here, right? And so if the prisoner comes by and reads that, they sign their name to it, and they can go find out more information and decide if they want to give a proper signature or not. If they don't, they walk past and they never even sign up for it. Where's the coercion in that? That's just a factor in their life. I mean, it's true if the offer had not been there that they wouldn't have taken it, but the fact that it's there doesn't force them to take it. It gives them the choice. And so they decide, do I want to or do I not? And so Cohen is going to go back point by point and show us that these coercions are just factors in the prisoner's life. And in fact, they are not dramatically different from the ones that we face as in the outside world on a regular basis. And so we have to take another thing into account. If we consider that these factors of prison life are coercions, then the similar factors that we face in the outside world are also coercions. And if that's the case, we can't give a signature of informed consent because we can't meet the volitional component either. And if that happens, then there will never be another medical experiment. Our medical knowledge will end right here and right now with what we have, and we'll never make another discovery. And I don't think we want that situation. And that's another reason why it's best to perceive these as factors. But again, let's look at what Cohen says. Mitford says that this is a coercion, that the body of the prisoner is not under their own control. They're regulated. They're told when to get up, when to go to bed, etc., etc. But isn't it the case that people in the outside world are facing something very similar? Doesn't the fact that your boss tells you when you have to be to work and when you can get off and when you can have your breaks, right? And the fact of that is going to dictate when you get up and when you go to bed. So aren't we also being regulated? Maybe not to the same extent as the prisoner, but aren't we still being regulated too? Security of the prisoner is the concern of the warden, right? You're not supposed to go out into the yard and shank somebody. You're not supposed to take the law into your own hands. Well, are we? Are we all supposed to become, vigilantes and go around taking the law into our own hands or something? No. We're not supposed to do that. We're not Charles Bronson. We're supposed to allow or trust that the police is going to take care of our needs. What about the issue of poverty? I mean, yeah, prison population, there's poverty there, and people may jump at the opportunity to acquire $30. What about people in the outside world? There's a tremendous amount of poverty that exists there as well. And if you took somebody living very rough and having difficulties and you said, hey, I'll give you $200 to participate in this experiment, aren't they also going to think about what they can do with that money? What about boredom? Prison life is boring. It's monotonous. It's the same thing. But isn't that the case with most people too? Don't we all go to the same places, follow the same routine, see the same buildings and the same people day in and day out too? It may not be quite as extreme, quite as limited as that of the prisoner, but it's still essentially that same basic concept, that same basic idea. So boredom is something that affects all of us. If the prisoner is going to be coerced by the fact that they're bored into doing something dangerous, Wouldn't that imply that all of us would? And finally, the desire for freedom. The prisoner wants a physical freedom. They want to get out of the confines of that prison. Those of us in the outside world, we're looking for a different type of freedom. We want to escape from poverty. We want to escape from boredom and monotony. That's why we're always trying to win the lottery, so we can do exotic things and interesting things, break up the boredom of life, not have to worry about where the next meal is going to come from and how I'm going to pay the rent this month. So those in the outside world are also looking for a type of freedom too. But the point is, again, if these are coercions, like Mitford says, then all of us in the outside world are coerced in this way too, which means none of us can give informed consent, and medical knowledge comes to a standstill. But these are not coercions. These are factors that we are going to look at and weigh. Okay? We are going to consider how far we're willing to go to escape from poverty. We're going to consider how far we're willing to go to escape from boredom. We are going to, as rational human beings, we are going to weigh the evidence that is given. We're going to hear what the risks of this experiment are, what is involved in it, what our compensation is going to be for doing so, and we're going to make a rational decision based upon it, whether we want to participate or not. And we want the freedom to be able to do that. That's what informed consent is all about, is making sure that we have that sense of freedom to be able to make that decision for ourselves. And the fact that someone has been put into prison doesn't mean that they've lost the use of their reason or intelligence. If that person is given the opportunity, then just like the people in the outside world, they are going to weigh the factors that affect their life. They're going to consider how far they're willing to go for the elimination of boredom or poverty or whatever, and they will make the rational decision for what is best for them. Do they want to participate or do they not? And so Cohen says that we do have to keep an eye on things and make sure that none of those old school type of genuine coercions are taking place. But as long as it's nothing more than someone coming in with an offer that you can accept or reject, there's no coercion. And in fact, it could benefit the prisoner by giving them the opportunity to make certain decisions. I mean, as a prisoner, yes, a lot of choices have been taken away from them. But there are choices that the prisoner makes too. And when a person is allowed to make decisions, particularly those that affect their own person, their own body, it is going to help build that sense of self-worth and self-esteem that so many prisoners are lacking. It will show them that they are of value, that they have a purpose, that there's something that they can do. And so it could actually end up benefiting the population. It could help benefiting the rehabilitation of that prisoner to be able to allow them to make that informed consent. And so that's the two sides that we have with regards to this issue. And as always, it's up to you to make up your own mind with regards to this. And so you'll have to decide for yourself whether you find that Mitford is right and that the prison environment is simply too coercive to allow prisoners to participate, or if you agree with Cohen that as long as we're careful in guarding the prisoner so that the coercions don't start to seep in, that we should be in good shape, that we should be fine. Okay. And we'll get a chance to talk about this a little bit later. On Thursday, of course, we have our cases 5 and 6, that go along with this chapter. Case 5, Back from the Dead, deals with the informational side of the issue and basically raising the question whether or not this doctor gave, who was it, Miss K, I think it was, did this doctor give Miss K enough information to make an intelligent and rational decision? Should her signature of informed consent be considered valid? And case 6, psychosurgery for a sexual offender, deals with the volitional component of things. Just like we had to do here with regards to the prisoners, what about someone who is in a mental facility? Here is a man who has been confined in a mental facility for the last 17 years. But the thing is that this person is perfectly rational and normal most of the time. It's just that every once in a while, these synapses fire in his brain. And when that happens, it forces him, it causes him to act out with aggression. And so he's in a mental facility because of the fact that it is his mind that is causing this aggression to take place. But again, that's only happening because of these firing of these synapses. The rest of the time, he's a perfectly rational, normal individual. And so the question becomes, does this person meet the volitional component to say, yes, I want to participate in this experimental procedure that could cure me and stop these things? Or should he be denied the ability to do that? Because after all, maybe he is coerced by his environment. And so take into account, as you're thinking about that, the things that Mitford and Cohen said. And keep in mind, again, that this person's probably not going to be asked to sign the paper while he's having one of these violent episodes. So the likelihood is he probably is reasonable and rational at the time that he's being asked to sign the paperwork. So those are the cases that are coming up. I hope you guys have some fun with that. So read those ahead of time, page 202 over onto 203. Read those ahead of time, and we'll have some fun with that on Thursday. Like always, any questions, any concerns, feel free to email me, and I will be happy to respond to you. So you guys have a great day, and we'll see you next time.